Good morning. My name is Doris Meissner, and I'm a Senior Fellow here at the Migration Policy Institute. I'd like to welcome everybody to this webinar today, which is entitled Family Immigration Policy and Trends, How the United States Compares to Other Countries. Now, this issue of family immigration has become quite prominent in recent months as both the administration and the Congress have begun to float proposals that would significantly change family immigration policy. And in so doing, they've often cited other countries very favorably, particularly Canada, but others as well. So MPI has taken a look internationally at immigration in the family arena, both in the United States as well as in 9 other OECD countries. And of course, what we find is what you would imagine, which is that there are commonalities and there are key differences. Our 3 presenters today are Julia Gillot, who is a Senior Policy Analyst here, Kate Hoover, who is an Associate Policy Analyst, and Demetrios Papadimitriou, who is a Distinguished Transatlantic Fellow at MPI and, of course, our former President. Let me start with a housekeeping note, and that is a reminder to everybody that audio and PowerPoint from the webinar will be on our website later today. Check migrationpolicy.org/events. Next, if you have any technical problems, please email events@migrationpolicy.org or call 202-266-1929. Next, if you have problems hearing via the web, please dial in using the call information sent to you via email. We will, of course, have a Q&A at the end of the call. There will not be a voice Q&A. So please type any questions into the Q&A or chat box on the right side of your screen and send to the host or to me or email to events@migrationpolicy.org. Finally, you can, of course, tweet your questions to @migrationpolicy or #MPIDiscuss. We also want to draw your attention to a report and a data tool that are being discussed on this webinar, but that we are releasing today. The report is its relative, a cross-country comparison of family migration policies and flows, and the co-authors are Kate Hoover, one of our speakers, and Brian Salant. And the data tool is called Modeling Potential U.S. Legal Immigration Cuts by Category and Top Countries FY 2016. So with that, we'll go to our presenters. We're going to start with Julia Gillot, who will explain to you the ABCs of the U.S. family immigration system.
Great, thanks, Doris. So as Doris said, I'm just going to give a broad overview of the U.S. immigration system, and then Kate will show how the U.S. system compares to other high immigration countries around the world. U.S. immigration consists of different streams, both authorized and unauthorized immigration, temporary and permanent streams. For the purposes of this portion, I'm going to talk just about the permanent immigration policy. So I'll be focusing on the green card system that allows people to obtain lawful permanent residence, or LPR status. The current U.S. immigration system was established back in 1990 and hasn't really changed since then, but it's built on a framework that was set up in 1965 when the United States abolished its national origins quota and set up a new system that was built heavily on family relationships. The system also allows employers to sponsor workers. It allows in people through humanitarian streams, asylees and resettled refugees. And we have the diversity visa program that allows immigration from countries that send fewer migrants to the United States. Within the family-sponsored system, some public conversations make it sound like people can sponsor any family members they like, but family immigration is limited to the categories listed here, to spouses, children, and for U.S. citizens, their parents and siblings. You can see that U.S. citizens can sponsor more categories of family members than green card holders can. And some of these categories face numerical caps, which I'll explain more in a minute, while others do not. So this pie chart shows the green cards issued in fiscal year 2016 by category. What you can see is that the biggest share are family-sponsored. Over 2/3 of green cards are family-sponsored. Employment's a smaller slice. It's 12% in fiscal year 2016, but has traditionally been around 14% of the system. Humanitarian is a reasonably large slice in fiscal year 2016. We expect that one to decline in future years. And the diversity visa is a smaller slice, and then there are a few other assorted categories. So I mentioned that some family relationships are given more priority within our immigration system than others. U.S. citizens face no caps on sponsoring their spouses, their minor children, or their parents, but all other categories have numerical caps. The largest cap is in the second preference. So within that, 77% of those green cards go to the spouses and minor children of green card holders. So that's about 88,000 green cards per year for the spouses and minor children of green card holders. 65,000 green cards per year go to the siblings of U.S. citizens, and then the adult children categories have those lower caps. In addition to these caps, no country can take up more than 7% of annual green cards issued. So as a result of these caps, the largest number of family-sponsored immigrants come in as spouses and minor children of U.S. citizens. This chart is showing the number of green cards issued within each family-sponsored category. And the spouses and minor children of citizens make up about half of all green cards within the family-sponsored categories. Parents of U.S. citizens took up about 22% of green cards within the family system in fiscal year 2016. And then based on those annual caps, the other categories had smaller numbers. These annual caps, as well as strong demand for immigration to the United States, lead to large backlogs. So the State Department estimates that as of late last year, there were 3.9 million people waiting in line for a family-sponsored green card. And these waits vary by category. So the shortest wait is for the spouses and minor children of green card holders. That's a 2-year wait at this point. The longest waits are for adult children and for siblings. The wait for a sibling visa or green card is at least 14 years and higher for Mexico and the Philippines. And then the adult children of both citizens and green card holders face long waits, particularly for immigrants from Mexico and the Philippines. Those can stretch to 22 or 23 years, depending on the category. This slide is showing some of the cuts to our U.S. immigration system that have been proposed recently. So the RAISE Act, sponsored by Senators Cotton and Perdue, the proposals put forward by the White House in the midst of the DACA negotiations, and the Securing America's Future Act would all propose to cut our overall size of our immigration system through cuts to particularly the family-based system, or what's sometimes called chain migration. And these proposed cuts would limit family sponsorship just to the spouses and minor children of U.S. citizens and green card holders. And they would also propose to cut the diversity visa. So there should be a word parents in red up here under citizens. That's showing a proposed cut, as well as adult children being cut, siblings, and adult children of green card holders as well. So in order to understand how these proposed cuts could affect U.S. immigration, MPI has released a tool today that allows you to look at how immigration from different countries would be affected by cutting different immigration streams. So the tool allows you to select one or more of these proposed cuts or categories to cut, and then see how immigration from different countries is affected. So if you've ever wanted to tell Congress which parts of our immigration system to axe, here's your chance to pretend you have that power and see what would happen. So here in the screen grab, I've selected all of the proposed cuts that were proposed by the RAISE Act. And these are the 10 countries that would experience the largest decreases to their annual immigration if 2016 trends continue. So what you can see is that immigration from Mexico would decline by 30%, from India by 45%, from China by 33%, and for Vietnam by 60%. And the URL for the tool is at the bottom. We invite you to check it out and play around with it and see what you see. So with that, I'll turn it back to Doris, but I'm happy to answer your questions at the end.
Okay, good, very good. Thank you, Julia. Let's turn now to Kate Hoover, who is the co-author of the brief that we're releasing today. And Kate will take us now to other countries and give us the examples of how these policies work in other parts of the world. Kate?
Thanks, Doris. So I will talk about how family migration policies and trends in the US compare with other OECD countries. So we looked at Australia, Canada, France, Germany, Italy, the Netherlands, Sweden, and the UK. So I think it's helpful to take a step back and talk about what we mean by family migration. Policies vary along 3 dimensions. The first is who's eligible to sponsor a family migrant. The US, Canada, Australia, and the UK apply one set of rules to citizens and permanent residents and another for temporary migrants. So citizens and permanent residents can sponsor their relatives to join them in the country, and their relatives either get permanent residence straight away or a provisional status that leads to permanent residence after a couple of years. Temporary migrants can usually apply to have their spouse or children join them in the country, but they receive a temporary status. EU policies for most member states, on the other hand, don't draw this distinction. So citizens and residents who are citizens of other EU countries can sponsor family migrants, as can non-EU nationals who've been legally residing in a member state for 1 or 2 years and who hold a residence permit of at least a year's duration. And it's worth noting that these requirements can be relaxed for certain groups, such as refugees. The second dimension is which family members are eligible. So all of the countries studied in this brief allow sponsoring of spouses or partners and children. And spouses and children account for the vast majority of family admissions in all of the countries studied. But options to sponsor relatives beyond this nuclear family vary by country. So Australia and the US allow citizens and permanent residents to sponsor parents. Canada allows citizens and permanent residents to sponsor parents and grandparents. The US allows citizens but not permanent residents to sponsor siblings and adult children, as Julia mentioned. It's worth noting, by the way, that other countries don't distinguish between citizens and permanent residents when it comes to who you can sponsor. Many countries allow you to sponsor dependent adult relatives, so this could be a parent who relies on you for care. And Australia, conversely, allows people to sponsor relatives who will provide them or another close relative with care. And Canada has an unusual provision called the Lonely Canadian Rule. This allows you to sponsor an extended family member of any age if you don't have a close relative who's a Canadian citizen or resident, or any other close relatives that you could sponsor instead. And then the third dimension is what status the family member receives. So in most European countries studied, everyone gets a temporary residence permit, although some groups may become eligible for permanent residence or citizenship more quickly than others. So in Germany, for example, a temporary resident is usually eligible for permanent residence after 5 years, but if you're the spouse or a child of a German citizen, you may become eligible after 3 years. In Australia, Canada, the UK, and the US, families sponsored by citizens or permanent residents usually get permanent residence, while families sponsored by temporary migrants get temporary residence. And this status matters because family migrants with temporary residence permits can face restrictions on their ability to work. So the EU, for example, allows its member states to bar family migrants from working for up to a year. And in the US, family migrants sponsored by certain work or student visa holders don't have automatic work authorization. So one example is spouses of people who hold H-1B visas. The UK allows most family migrants to apply for work authorization, but it bars them from working in certain occupations, for example, as a dentist or a doctor. So in France, Germany, Italy, the Netherlands, and Sweden, between a third and half of all first residence permits were issued for family reasons. These European data can include people sponsored to join family members who are already in Europe, and they also include relatives who are accompanying a migrant in another category. So, for example, a spouse accompanying a temporary worker. We also compared the US with other countries with data on permanent migration. So in this case, Australia, Canada, and the UK. In the US, family-based migration is a much larger share of permanent migration compared with Canada, Australia, and the UK. So between 2012 and 2016, family accounted for about 2/3 of permanent residence grants in the US, but between 27 and 29% for Australia, Canada, and the UK. But it's worth noting that these headline data miss 2 important points. So the first is that they exclude family members who arrive through other admission streams. So, for example, when an economic migrant brings their spouse and their children. When you count these accompanying family members as family migrants, it becomes the biggest immigration stream in Canada and the UK too. So using 2011 to 2015 data, we found that the share for Canada rose from 27% to 66%, It rose from 32% in the UK to 57%, and it rose again in the US from 65% to 81%. And when you adjust family migration admissions for population size, we see that Australia, Canada, and the US admit family migrants at similar rates. So in the US, that's about 2.1 admissions per 1,000 people. In Australia, it's about 2.6, and in Canada, it's 2.0. In fact, while the rates for family migrants are similar, the data show that the US admits far fewer economic migrants than either Canada or Australia. So this is about 0.5 admissions per 1,000 people in the US, compared to Australia at 5.5 admissions and Canada at 4.5 admissions. And in turn, when you count accompanying family members admitted through other immigration streams, the picture changes again. So Canada ends up admitting family migrants at almost twice the rate of the US, about 4.8 admissions per 1,000 people compared to the US, which is 2.6. So what does this all tell us? Systems for admitting family vary considerably by country, both in terms of who they admit and how they admit them. And this brief doesn't really delve into detail about the profile of family migrants in different countries. So we don't look at what countries they come from or what their skills levels are. But this analysis does tell us that family migration is an important part of immigration systems across all of the countries studied, especially when you count both family reunification channels and accompanying family members in other categories.
Okay, Kate, thank you very, very much. So we now turn to Dimitrios Papadimitriou, and I think it's fair to say that there is nobody that has deeper expertise or broader experience with all aspects of immigration systems, both in the U.S. and around the world, family as part of that, as well as the other elements of immigration systems. So Dimitri, give us the context here. Tell us how to understand all of this and where this issue of family immigration fits in the overall design of immigration systems.
Thank you, Doris, and good morning, everyone. First, I wanted to thank my colleagues here who have preceded me in this conversation for fantastic work, because mining all the differences and all the different systems and then trying to make some order out of it, which is sometimes a full errand, has been extraordinarily useful. So as Doris said, I will sort of create a bit of context there. And I want to get one thing out of the way early on. The family immigration system has two things going for it, at least as far as the interests of the host society are concerned. And we tend to forget that. The first one is it provides a safety, a private safety net, particularly during the early months and possibly a year or two after entry. That is, in one sense, the biggest argument for having a family immigration system that is as broad as ours is. The second one, and this perhaps is not as easily understood, although we all know it, we see it in everyday life, is that it assists quite effectively with the labor market incorporation of newcomers, especially in the mid and lower skills, which is where most jobs are and which is where most family immigrants find employment. And the importance of this second point is very critical. Insufficient understanding and knowledge about the labor market, what we call labor market information, is essential, particularly for countries in which the overwhelming majority of jobs change hands, not in a formal way by going to some sort of a job data that is, in a sense, controlled by the government and or unions, organized labor, et cetera, et cetera. So if you're going to have to, in a sense, function economically in a place like the United States, you need to have that labor market information, and that is what families typically provide. And assuming, of course, that the family member has roughly similar human capital characteristics as the principal, you're going to increase the possibility that they will find a job because they're going to be inserted in that part of the labor market. Now, let me say a few things about comparisons and about the wonderful work that Kate and Brian have done. Comparisons across systems are always tricky exercises, and one is forced to create many conventions. And that's what you will see in the paper that is just released or was released earlier today, whatever. Let me, in a sense, organize that in a couple of different ways. The one category that is fairly common, in fact very common across all the systems that we studied and most other systems that play in the immigration game, is the one relating to refugees. And the family reunification behavior and access that refugees have is fairly common across that class of countries that we have discussed. And it is so because it is regulated by international law and practice. So refugees will be able to sponsor their family members for the very obvious reasons. If you're trying to save somebody from persecution, et cetera, you better save the entire family rather than, sort of part of it. So that makes it obvious that the ratio between principals and dependents in the refugee program is roughly the same. And you will see this in the various charts that the paper has produced. The second point is, what about the economic streams? And by economic streams, I mean both the employer-led, which is the U.S. system, demand-driven, another way of looking at it, and the point system that several other countries have, what our president has called repeatedly a merit-based system. So those streams are also very similar in terms of across the states that we've discussed and many others, in that principals are allowed to bring their immediate families, and in that the multiplier effect tends to be fairly small and fairly uniform across different countries. So these are people who are often younger, who are professionals, who have smaller families, and as a result, the multiplier is somewhere on either side of about 2. In other words, an additional person plus something. And this is, again, common, and it comes out as in the paper that Kate and Brian have produced. The biggest difference among states, and in that way I will repeat something that Kate already said, is the definition of the family and the distribution of family visas versus economic or employment-based visas. These are the key differences. And when you do that, there are 2 things that come out, 2 or 3 things that stand out in this regard. The first is that unification. By that I mean moving a person with their immediate family, or reunification, the ability of someone after they have entered one of the countries to bring their immediate family, which is, as you heard, spouses and minor children, is offered almost universally. Now, the emphasis is on almost. It is offered universally in the advanced industrial world, democratic advanced industrial world. So, everything from Europe and the United States and the other English-speaking countries, etc., although it's not perhaps the same in some of the newest countries, particularly one of the countries that will be a very large destination of immigrants in the next 20 years, such as China. So it is offered almost universally, and part of the thing that we need to understand this is that it has been enshrined in international law. It appeared in the conclusions of the 1994 World Population Conference in Cairo, and this was something that some of us will remember, because prior to that time, this was not the case for most of the European countries. So by accepting the conclusions, having participated, in drafting the conclusions, these countries fundamentally have had to change their laws and be able to, behave the same way that most everyone else has. And of course, since the advent of the European Union in 1992, and then subsequent, regulations and legislation and all that, it is now part of European law. So expect not only the 27, soon to be 27 countries to practice this, but also the 2 or 3 countries that are not members of the European Union in Europe, Switzerland, etc., Norway. These countries also practice that. But beyond that common standard, the variations are massive. And again, I don't want to repeat what Kate said, about parents and minor children and adult children and adult married children and brothers and sisters. The examination and the explanation of these differences are unique to each country. And one thing that they all share is domestic politics. Fundamentally, family lobbies have been able to basically maintain at least the standard that they started with in the United States in the 1965 Act. And for the countries that have been in the immigration game longest, those lobbies, just like employer lobbies in practically every country, have been particularly powerful. That is the case in the United States and, of course, in Australia and Canada and elsewhere, what we call very often the overseas English-speaking immigration countries. And I'll give you 2 examples, and I'll stop there, Doris. The first one, of course, is the 1965 Act. And we know what happened there. People were selling the 65 Act. There is an argument as to whether they had thought it through completely, as an opportunity for families, and particularly extended families of places like Ireland and other European places, to be able to come to the United States. And they passed the Act, and of course, the way that these things interact with each other turned out that the Act was a great opportunity for all the rest of the world to be able to come to the United States through the family immigration system, for a very simple reason, that the Europeans didn't really need to come to the United States, beginning with the 1970s. The second one is Canada. And Canada is a particularly interesting case for this conversation today. Canada has a very strong family lobby, but family immigration and definition of family is also enshrined in the 1982 Canadian Constitution. In 1982, the Canadians imported their Constitution and they developed it. And so all of the legislation on these matters is, in a sense, by constitutional right. So in the mid-1990s, when Canada decided to just increase dramatically the number of people who were coming through the economic stream, that merit-based system, they did so by enlarging the pie. In other words, instead of trying to take visas from the family stream or from anybody else, they just expanded the total number of visas. And that's what you see in Canada. And that's all I have to say. Well, one more thing. This way we understand one final point about family immigrants. Not all family immigrants are created equal. In other words, the families of merit-based or selected immigrants, who tend to be overwhelmingly professional, they tend to be of the same social and economic class. Families from a purely family reunification system, they also tend to have the characteristics of the people who sponsor them. And that is, in a sense, the biggest difference between the family members in one type of country versus another type of country. There's merit in both positions, but that is left to a country's politics to figure out. Thank you.
Okay, thank you very much, Dimitri. And we have a question from the audience that actually picks up very clearly on that final point that you made, so I'll ask it to you in just a moment. We're now opening the floor for Q&A, and inviting all of you who are listening to use the Q&A function. It's on your screen, or you may also email events@migrationpolicy.org or tweet to @migrationpolicy, #MPI discuss. Okay, so Dimitri, picking up on where you finished, the question that I have from the audience is, which immigrant group between family-based and employment-based adjust to the receiving countries better economically, culturally, and politically?
Well, different countries have different expectations of what the word adjust means, okay? The emphasis in most countries is, and the indicator that they follow most closely, is adjusting into the labor market. So labor market integration is most frequently the measure that you use. Of course, language, and in the last 10, 15 years in the United States and elsewhere, all sorts of civic culture and things like that also enter into the equation. So for people who are coming in through a selection system, they adjust, but part of the reason that the Canadians and the Australians and others have changed their system in the past 2 or 3 years, since 2012 in the case of Australia, 2015 in the case of Canada, they adjusted it in part by bringing in the employer and or various subunits, provinces in the case of Canada, state in the case of Australia, into the selection system. So, because that allows people to go directly into a job. This has always been the advantage of the American system. You have an employer for those, the employment-based visas, that the person can join the day after they come, or whatever it is, the week after they come to the United States. So labor market incorporation is sort of the measure that everybody looks at. But different countries go beyond that. Language is extremely important. In fact, in all of the selective systems, Canada, Australia, New Zealand, et cetera, the English or French language in the case, in other words, knowing the official language at a very high level, is a requirement for people to be able to come into these countries. We don't do that, and we don't do this for a number of reasons. First of all, we have very large ethnic communities in which people can incorporate themselves, although that limits terribly the ability of people to actually sort of be able to get much higher in terms of their economic status, because the job ladders within an ethnic community tend to be fewer than the job ladders in the broader community. The issues of culture and civics, et cetera, are very, very messy. The Europeans try very hard to impose requirements like that, but I don't think that anyone can really go out into a public meeting and say we have been successful.
Okay, thank you very much. Let's go to a further question, which I think perhaps Julia you might answer, and that is, what's the status of policy changes to family immigration in the United States?
So right now it's just a conversation that we're having in the country. As I mentioned, there's the RAISE Act that has been proposed to cut the size of the overall system. The White House has supported this as part of the DACA negotiations, but Congress really hasn't shown that it has the appetite to take this on right now. As we've seen, Congress has been unable to deal with the issue of Dreamers, even though that has wide public support. The public support is much more mixed in terms of cutting the size of our immigration system or cutting certain family-based categories. So I really think it's going to be a long debate that we'll have and an ongoing debate, and we don't expect to see new legislation anytime soon.
Can I add something to this, Doris?
Please.
Touching the permanent system in the United States has proven to be the third rail of politics. People have tried it. Some of you may recall the debates in 1987 and 88 between Senator Simpson and Senator Hatch about putting some requirements to the immigrants who come to the country. Needless to say, Mr. Simpson and the others who thought that there would be more requirements lost. So what we have always done, and this is what we did in 1990, and Doris, of course, you know this as well as anyone, we basically bypassed the system. So we created a more elaborate non-immigrant system, the non-permanent immigration system that would be able to accommodate the goal of the 1990 Act, which was to add to the competitiveness of the United States by bringing in more skilled immigrants. That's when H-1B was created and all of these other, O, et cetera, all of these other categories. And I don't think that a country can afford to constantly be going around, the core of the system in order to accommodate other priorities. But just as Julia said, it must be one of the most difficult things that Congress would ever have to do because of the power of special interests and lobbies on either side of this issue, on each of the many sides of this issue.
Okay, another person in our audience has asked a question that I think needs to go back to you, Dimitri, and that is there any evidence that there's greater flexibility and success by family-based immigrants who work in moving up in the labor market compared to labor-based immigrants, given the labor-based immigrants' ties to a particular employer?
Well, I wish I could answer that question because we all live in a country, I'm sorry, for those of us who are from the United States, in which one of the many things that we're lacking is the fundamental curiosity as to how is it that our various immigrants fare by immigration category. Since the mid-90s, in the case of Australia, and a little later than that in the case of Canada, those countries have had longitudinal studies that follow immigrants, different categories of immigrants from the get-go, from the time that they get. So they can tell you, how different immigrant groups are faring, how different categories of entry, the people who come in those entry categories are faring, and that is the basis on which they adjust their selection formula. As you will recall, Doris, because you were the executive director of the report that we issued back in, help me out, 2006?
Yes.
Okay, 2006. We had a commission or a task force that we put together on this. We actually recommended that indeed that we should be doing, these kinds of studies, which then would allow us to tweak the system. But needless to say, all these efforts went down, which Julia suggested, which is to nowhere. So far.
Okay, let's turn back to Europe because we have an audience member that has asked about Germany and Sweden and is asking, why does Germany and Sweden restrict family migration for some newly arrived refugees? Is that legal?
Oh, you want me to? Okay. So Germany and Sweden and many of the other European countries have sort of at least two categories of offering protection. The first one is the convention refugees. People who are convention refugees, in other words, they have been in the United States, we would say they have been resettled. In the case of Germany and many other countries, they have been judged to be refugees according to the 1951 convention that set up the global system in this. These people have the right to reunify. But there's a second category that's extremely broad, and it's a secondary protection. People in that secondary protection don't really qualify as refugees, but countries don't want to send them back, or European law forces them to keep them in these countries. And since 2015, late 2015, perhaps early 2016, these countries decided that they would limit the family reunification of these people for 3 years. In other words, for the first 3 years, you could not bring your family. The expectation here is that something will change dramatically in the countries from which they came, and that these people would voluntarily want to go back. The other expectation is a political expectation. You know, on top of all the people that came into these countries in 2015 and 2016, they did not want, you know, to basically go to their electorates and say, you know, we're still getting this many people through family reunification. This has been modified in the case of Germany as of a month ago in the new coalition, whereby they will allow up to 1,000 family unification immigrants for these secondary protection people per month, a total of 12,000 per year to come in. This was a demand of the Social Democrats and part of the price that they extracted in order to be part of the governing coalition.
Okay, another audience member is asking, again, where the United States is concerned, to talk about any economic data that might be available regarding the creation of jobs by family-sponsored immigrants. In other words, the entrepreneurial characteristics that immigrants are.
You want me to?
I can start.
Why don't you?
Right.
Yeah.
So as Dimitri said, unfortunately, what we really lack in the United States are data that tell us how people came into the United States. So we can see that immigrants overall are more entrepreneurial than U.S.-born people. They're more likely to be self-employed. They're more likely to employ other people to start businesses. But what we can't see is whether those people who came through family-based channels are more likely to be self-employed than those who came through employment-based channels. You might expect that to be true because the people who came through the employment-based channels initially had an employer who sponsored them, so they at least at some point, you know, chose to work for an employer rather than be self-employed themselves. But we don't have the data to really allow us to disentangle that.
It sounds like a refrain, a common refrain. We don't have the data. My guess, if you will allow me, Doris, to take a guess on this, is that we're talking about two types of entrepreneurship. You know, the first one at the high end that create companies, et cetera, many of which start in someone's basement or garage or in, you know, a house where 20 or 30 programmers are working toward the same goal. This will tend to be from people who are well educated, et cetera. On the other type of entrepreneurship, starting with small companies, you know, initially starting as a necessity in order for people to basically survive, that is the kind of entrepreneurship that we often see, and that is something that is extremely important in the United States. Our entrepreneurship rates tend to be much higher than just about every other place. Germany has done a little better than in the past, but still far lower than ours. And what we see there is essentially the same kind of combination of trying to do better for oneself and also the kind of opportunity-seeking family migrants. So yes, there is entrepreneurship that is happening at all levels, and family is probably contributing its share to the overall thing.
Okay, I think there is a question about naturalization and the differences in naturalization from country to country. Kate, you talked about this a little bit in your comments. Maybe you could elaborate a little bit more on the differences in naturalization, the ability of people to naturalize out of the different streams.
Sure. So I think it's helpful to distinguish between family migrants who get a temporary residence permit and those who get permanent residence. In Europe, it's common for family migrants who get a temporary residence permit to then have to wait 5 years before they can get permanent residence. And while the naturalization requirements vary from country to country, you're looking at about a decade, maybe slightly more, maybe slightly less in Europe before a family migrant who comes in will then be a citizen, and they'll then have the rights to vote and be a full participant of the country. In the US and other countries, again, the policy for naturalization varies from country to country, and perhaps Julia could speak to the specifics in the US. But they get permanent residence if they're being sponsored by a citizen or a permanent resident. And that opens up more opportunities straight off the bat. So you can find a job, you can live, work, and study freely, and then you're that much further along to then being able to naturalize then in Europe, for example.
Yeah, and in the United States, whatever channel you come through, whether it's employment-based or family-based, once you get that green card for lawful permanent residence, you're then on a 5-year clock. After 5 years pass with that green card, you can then apply for U.S. citizenship. In the meantime, you have most of the rights of U.S. citizens, some limited access to public benefits. You're not able to vote. If you want to work for the government, you might be limited in which positions you can work in. But then once you get the citizenship, you have the same rights as any U.S.-born person.
And we have had research here at MPI and elsewhere that identifies and measures the naturalization advantage in terms of economic outcomes, and it is a significant advantage. I suspect that naturalization in Europe may not be as meaningful as it is in the United States, because, as Kate said in her presentation, what we would call legal permanent residents have just about all the benefits that they would as if they were Germans or French or what have you. And in many European countries, and that's sort of like the way that the tendency that this particular point I'm about to say is moving, you have access to the elections at the local level as long as you're a permanent resident. So I imagine, that, the naturalization urge, as it were, may not be as high there. The other thing is a lot of the countries that send from which immigrants to Europe hail tend to be countries that don't want their nationals to naturalize, because this way they continue to exert some power. This is a classic case with Turkey, of course, and I suspect many other countries.
Okay. In Julia's presentation, Julia, you talked about how long the backlog is in some categories of relatives coming to the United States. There's a question here from the audience about Europe and processing family unification applications. Kate, maybe you can take this. What impact did the migration crisis have on the ability of EU member states to process family unification applications?
So in the EU, we don't see the same capping of family migration as we do in the United States or other countries. There isn't the sort of case where demand just outstrips supply. But in the migration crisis, we really sort of saw a strain on the capacity of migration agencies to process family requests. So as of early 2018, we found that processing times in Sweden for spouses of some countries ranged from 11 to 24 months. And these wait times really varied by the nationality of the family migrant. So we saw, for example, Iraqis, many of whom arrived during the recent crisis. The waiting time became 11 to 16 months, and Somalis, the times range between 21 and 24 months. So we really sort of see an uptick in demand from certain countries, really sort of overstressing the capacity of different migration systems to really sort of process family cases. And as Dimitri said, there was also, subsequent delays in when you could start applying for family reunification as someone holding subsidiary protection in Germany and Sweden.
Another question about Europe has to do with income requirements in the different immigration streams. How do countries differ according to what requirements they impose on income for incoming immigrants?
So the crux of that is essentially ensuring that if you're sponsoring a family migrant, you can provide for them without them having to fall back on the state. So commonly what we see are sort of a material requirement where if you're a sponsor, you have to prove you have a certain level of income. This varies enormously by country, as you would imagine. In the UK, for example, it's about £18,000 a year if you're sponsoring a family member from outside the EU. But there are also other ways of measuring that sort of ability to support your family. So another common requirement is your accommodation. So some countries will ask you to prove that you have accommodation of a certain size to house your family. And so there are all these different measures which are really essentially trying to get at the ability to support your family member and to ensure that they won't then sort of rely on the state as soon as they arrive, and that they can sort of, look after themselves initially.
And this is something that it appears in most immigration systems. There is an income requirement and a public charge concern. The two tie together. And I'm not quite sure that any country enforces this requirement any more stringently than we do, because, we don't really enforce that requirement. You remember, Doris, you were a commissioner when we added all these things, I believe in 1996. But in most instances, these are sort of paper requirements rather than, requirements that would lead to somebody not having access to whatever, medical benefits or things of that nature. But this is something countries learn from each other, and they sometimes copy blindly. So this is one of the instances in which you have an awful lot of countries sort of having the same things in the books, but none of them being particularly tough in implementing those legal requirements.
Okay, well, we're going to close with a pretty political question here from the audience. And perhaps, Dimitri, you can answer this, Julia. The question is, negative commercials about chain migration have been playing in the United States. How can family-based migration best be framed in ways that negate this fear-mongering message?
I can just start with a bit of a quick fact check, if that's all right. So these commercials, I believe, is referencing the commercials where they talk about family migration, and then the screen quickly fills up with stick people, suggesting that one person could sponsor hundreds of people over their lifetime, and that's simply not how family sponsorship works. Just because family sponsorship is limited to the certain categories in the United States that I had shown, and there are these backlogs and wait times for sponsoring family members, and because you need to be a U.S. citizen in order to sponsor other family members, and there's a lag before you can obtain that citizenship, and then there are processing times for that sponsorship. And also, simply people's families aren't that large. At a certain point, you've sponsored everybody that you're related to, potentially, through the system, and that still wouldn't lead to the numbers that are sometimes shown on the screen in these commercials. So I think there's an exaggeration in some of the fear-mongering around family sponsorship.
Well, certainly there is an exaggeration. This is the only way that you can make a political point by, sort of going from exaggeration to hyperbole and then to crazy things. In the 1950s, when things were of an entirely different, I guess it was a different era and the laws were different, there were examples where somebody, brought everybody, because the restrictions were not the same. They were much easier. The family unity is a basic principle in all immigration systems. We define family unity differently. And in the beginning of my presentations, I suggested why we do that. I think what is a choice, and this is the, what this country will have to contend with and try to figure out in the next, 6 months or 10 years, the ratio between, family and economic migration. In other words, the question that we need to answer to the satisfaction of our politicians, this way we can pass legislation, is how much should immigration be a direct contributor to economic growth and competitiveness? And if the answer is that it has to be more, the second question, that subsidiary question, is do we do this by increasing economic immigration and leaving family immigration alone, alone, or do we create a zero-sum game whereby the gains in the economic immigration stream translate into losses in the family immigration stream? And I think these are the tough choices that we all need to think about harder if and when the Congress really takes this legislation up.
Okay, well, I think that's a very apt final word here. And so we're at the end of our time. We'll close out now. First of all, of course, I want to thank our presenters and in particular the analytic work that led to this webinar. Then to thank the audience for being with us today. Let me quickly review again the resources that are available as a result of what we are releasing today, and that is that the slides and the audio from this webinar today will be available at www.migrationpolicy.org/events. The report that we discussed today, which is entitled Its Relative, a Cross-Country Comparison of Family Migration Policies and Flows, again, written by Kate Hooper and Brian Salant, is available on our website. And then finally, a new data tool, Modeling Potential U.S. Legal Immigration Cuts by Category and Top Countries, fiscal year 2016. It, too, is available on our website and at the address on the screen. Finally, if there are any reporters who are listening who have further questions, we do invite you to call our Director of Communications, Michelle Middlestadt. That number is 202-266-1910. Thank you all.